Welcome to an oral argument session of the Sixth District Court of Appeal. We have two cases on our docket this morning. Before I call the first case, let me just say, gentlemen and lady, thank you very much for accommodating the last minute request to change the time. Really appreciate it. This is being live streamed on YouTube. If you haven't already silenced your cell phones, I would be much grateful if you did. To introduce the panel, I've already been introduced. I'm Dan Traber. I'll be presiding today. To my right, your left is the Honorable Carrie Ann Wozniak, and to my left, your right is the Honorable Joshua Mize. The first case on our docket today is Sheila Pierre versus State of Florida, 23-3308. Mr. Pennell, will you be making argument for Mr. Pierre?
Yes, sir.
How much time would you like for rebuttal?
5 minutes.
Great.
Please the court. My name is William Pennell and I represent Sheila Pierre, the appellant in this case. As I indicated, I'd like 5 minutes of my time for rebuttal. As noted in our briefs, it's our position that the trial court committed 6. Cumulatively, they require a reversal of Mr. Pierre's convictions in this case. We acknowledge that the court provided the parties with a notice to specifically address harmless error as it relates to issue 3. I will make sure to address that. I think it makes more sense to address issue 1 first, because if the phone evidence is suppressed, then the harmlessness of that kind of goes away. Most of the evidence in the case did come from the phone. So it's our position that the trial court's first error was denying the motion to suppress the cell phone evidence obtained from Mr. Pierre's phone, because at the time that the phone was seized by Deputy Mercado of the Broward County Sheriff's Office, he did not have probable cause to believe that there was evidence of criminal activity on that phone. At the time that he seized, and obviously the court's aware of the probable cause standard, it's a probability, according to the 11th Circuit, a substantial chance that evidence of criminal activity would have been discovered. At the time Deputy Mercado seized the phone, he seized the phones of all 5 or 6 individuals at the body shop. He testified that he didn't seize it based on any particular suspicion, but all of them were around the car, and it was standard policy to take the phone before they transported to the sheriff's office.
Counsel, it's the precedent of this court. I think it's the Hickman case, and this was just applying a Florida Supreme Court precedent. The officer's subjective view is not important. So say he seized all 5 of those phones and in his head did not, have a view that would give him probable cause. And if he didn't have probable cause as to the other 4, right, that ended up not mattering if there was objectively probable cause as to the phone that subject of suppression was appropriate, correct?
I agree with the court's analysis, other than it is an objective analysis, but it has information in possession of him.
Information in possession of him, but he doesn't have to realize it gives him probable cause.
Correct. If he misbelieves that he does not have probable cause and he actually does, then suppression should be denied. So I agree with the court on that. In this case, the officer did not have probable cause under the objective standard because the information that had been conveyed to him by the members of the Orlando Police Department did not give him any information about. All he knew was that this vehicle was suspected of being in a shooting in Orlando. He did not know how the OPD had determined that the vehicle was involved in a shooting, how it had been tracked to Broward County. He was not given any information about the clothing description of the individual driving the vehicle at the time of the shooting. And in direct response from a question from the trial judge, he indicated that he knew nothing particular about the crime other than the vehicle identified as the vehicle involved, but knew nothing about a suspect being identified. So it's our position that he didn't have the particularized suspicion to Mr. Pierre, and more importantly, to the phone. And I think that's consistent with this court's decision in Jefferson, that says you can't just speculate there's going to be information on this phone that's relevant to the crime.
Driving the car, didn't he?
I'm sorry?
Didn't the detective saw Pierre driving the car?
Someone driving the car in Broward County. He saw.
He knows it's the car that was involved in the crime.
Yeah.
And he knows this, he drove the car. And he saw him removing stuff in the car, right?
It did. I don't think that's sufficient. I think under Jefferson, there was far more evidence of that connecting the defendant and than the phone to the crime. And this court found at the time of the seizure in Jefferson, the victim was dead. The trail of evidence led to Jefferson's apartment. Jefferson was previously acquainted with the victim and was at her apartment on May 24th. Her body was found on May 26th.
He knows the car was involved in a murder a few hours before. He now sees just a few hours later, your client driving the car. And not just driving it transiently, but removing things from it as if he had occupied it. That doesn't give probable cause.
He sees multiple people around the car. He sees two different people driving the car. They attempt to detain one of them, and that person flees the scene. They do eventually detain him, but they see
But even if you see multiple people driving the car, seeing one indicates he was involved, very well could be involved with that car. In the hours leading up,
he
right?
could be involved in the car. He could be involved with that car.
More could be. It's very likely involved with the car. He's
So
driving it a few hours after.
He's involved in the car 3 hours after the shooting, hundreds of miles away from the shooting. We don't know if people switch, there's a different driver. I don't think it rises to a probability that there's going to be evidence on his phone. Maybe probability that there's evidence in the car, but now I think you're speculating to go to his phone, pursuant to this court's decision in Jefferson. So it's our position that, when he explicitly says that he had no information regarding the suspect, that he's just doing a general detention and seizing phones of everyone at the scene, he doesn't have the necessary probable cause, the particularized probable
I think
cause.
that goes to the subjectivity, right? Whether he believed he had probable cause, or I get you. Maybe he didn't have probable cause as to all the cell phones, but those ones aren't an issue.
No, I know, I understand it, but
That's
objectively.
kind of a red, you said, that's a red herring to me.
Oh, okay, that's fine. I don't think him seeing Mr. Pierre nearby the car hours after the shooting, hundreds of miles away from the location of the shooting, with no information specifically from OPD that he's a suspect, gives him probable cause to seize the phone, maybe to search the vehicle.
Because I want to get you to the harmless error, because I want to make sure you have enough time to address it, and I have some real questions.
Sure.
In looking over the harmless error case law in preparation for this case, for something that comes up as often as it does, it's really surprisingly unclear and kind of difficult to work in practice to me. And here's what I mean by that. You take this case, for example, the state's only argument here was that the evidence was overwhelming.
Right.
Okay. The Florida Supreme Court has, as explicitly as you can, categorically rejected that as a basis for harmless error. And I think they actually have used the language in at least one case. We explicitly reject this argument as a basis to show harmless error. That's not an exact quote, but it's pretty close. And so if overwhelming evidence isn't sufficient, which the Florida Supreme Court has told us that it's not, what I'm wondering is, what is the proper way to evaluate whether improper evidence influenced a verdict? As I was thinking about it and understanding what the Florida Supreme Court has told me you can't consider pretty clearly, I really struggled to think conceptually, what other good way is there to evaluate the question? I mean, if overwhelming evidence isn't right, what's the right way? And I really didn't see a clear answer in the case law, which is surprising for something that we deal with on an almost daily basis. So I noticed in your reply brief, you responded to the state by essentially saying that the evidence was not overwhelming and that you think the evidence favored your client's theory of the case, which you took the other side of the argument, but you actually kind of bought into their overwhelming evidence framing by saying we disagree, the evidence was overwhelming. So can you take me through your view on what is the way to evaluate this?
Well, the court is right that the Supreme Court has explicitly rejected the overwhelming evidence standard. The only case the state cites is the Smith case, the second DCA in 1998. And what that court says is the harmless error analysis provides a useful tool to shield our criminal justice system from unnecessary retrials in which, quote, negligible error would not change the result. They go on to say the harmless error doctrine should not, however, become a sword used to deprive even the most guilty defendant of a fair trial. We don't think the evidence is overwhelming, but if the court does think the evidence is overwhelming, that second sentence says that doesn't mean it's harmless.
I get it. I agree with you.
So-
Overwhelming evidence.
So they're talking about negligible error. So
How do we frame it?
I think a negligible error would be something more like an improper ruling on a hearsay objection to something that wasn't very important. Or maybe in this case, if you had a photo of another handgun, maybe that could be harmless. But when you have a photo of an assault rifle, a video of Mr. Pierre exposing and bragging about his genitals, and text and audio messages about dealing in firearms, I don't think, given the substantial prejudice from those three things, you can.
Well, how do we evaluate something like that? So I get the case law is pretty clear that evidence of guns unrelated to the crime is error to admit it. And I could certainly see it's not, in my view, it's not just whether it's something that should cause the jury to have a bias against your client, it's whether it's something that could, properly or improperly. In other words, even if a jury shouldn't hold gun ownership against somebody, if there's some percentage that might, it could be a problem.
Right.
But you take like, how prejudicial is it? Like you use the term assault rifle. I didn't see anything in the record that showed why this is an assault rifle,
Sure.
as opposed to say any other type of rifle. And that seems to me to kind of play up the prejudice. So I guess I would say that seems to me to be a sliding scale. We're like, well, how inflammatory was the error? And that seems to create line drawing issues. That's what I took from your analysis of the second PCA case. Well, how inflammatory is the error? How difficult is the error? And I don't know how to draw that line. And I'll ask you in this case specifically, like what made this an assault rifle as opposed to a rifle? Were there some characteristics you saw that made you classify it as an assault rifle when you argued to us that it was particularly inflammatory because it was an assault rifle?
Well, I'm certainly no gun expert, and I'm based on previous oral arguments, I'm aware that you are. So I would first point out that the state did not are calling it an assault rifle themselves. So I think the common understanding of a person viewing that firearm would believe it's an assault rifle. And based on my viewing, it appears to be similar to weapons that have been used in mass shootings and things that would likely to inflame jurors. It does not look like a pistol that generally people look upon as something that is used for self-defense or protection. It also doesn't look like an old school hunting rifle that you're looking like to shoot a deer with. So I think that's pretty clear from just looking at it. The contrast between the photos of the Glock and that photo are pretty drastic.
If I look at DiGiulio, and everybody seems to agree that that's where this comes from, it talks about the test being, it didn't contribute to the verdict, or alternatively stated that there is no reasonable possibility that the error contributed to the conviction. It's weird for me that we can't consider overwhelming evidence in that calculus. So I wonder if the Supreme Court's admonition that this isn't an overwhelming evidence test means it's not exclusively an overwhelming evidence test. For example, say your client, and I know he didn't do this, I'm just going to use it as an example. Say the second that he was arrested, he confessed. And that moreover, in this particular case, there was 17 different angles of high-res video showing him actually shooting Miss Forward. And the same error of showing this extra gun occurs. How could we not factor the confession and the 14 different angles of high-res video showing the shooting?
Well, I agree with the court that you have to look, after they say overwhelming evidence standard, they say you have to look at the admissible evidence and the inadmissible evidence. So they are saying it's not solely an overwhelming evidence case, that you have to compare. But what I think they're saying is what the court is saying, and what the Smith court says is, in a different case, this would be harmful, but in this case, we have a confession from the defendant saying he engaged in sexual activity with a 6-year-old because he, quote, was unable to resist her advances. So it's kind of hard to ignore his own words that he did have sex with a 6-year-old, and that's a different situation. We don't have that here. We don't have a confession. We don't.
Well, in this case, you have, oh, go ahead.
I was just gonna say that, that's the overwhelming evidence framing though. You're just explaining as to why the evidence is overwhelming there, but not here.
What I think Judge Traver is saying, and I think what the cases bear out is, if it's even more than overwhelming, like it's,
Really overwhelming?
I don't know what to call it, but indisputable. I mean,
I'm not being flippant, it's
no,
genuine.
I agree with you. So I think the way the cases bear out and what makes sense is harmless error would be more appropriate in the case where you have a confession, where you have an eyewitness, especially an eyewitness that doesn't have a motive or bias in the case.
Let me cast it to you this way. If we're going to look at the effect on the trier of fact, we're going to look at the contributing. It's not mentioned during opening. It's not mentioned during closing. The entire case is about an effort to establish that your client was the man in the jogging suit and the black Impala. State does a good enough job of that trial counsel effectively concedes the point in closing that he was that person. And the theory was there must have been somebody hiding in the back seat. There is a comment that multiple women on the jury were aghast, which is a great word, at seeing your client's genitals, coupled with the fact that the question placed before them for their deliberations was whether your client was the shooter, not whether he was there or what he shot the victim with. It suggests that nobody needed to watch this video during deliberations. Also, if you look at the transcript, it shows that clearly the assault rifle wasn't shown to the jury during trial, because you can see in the video, it says, and there is the other one. It doesn't say that in the transcript. The trial court says, you were reading my mind. The state said I stopped it. So it's pretty clear to me that the jury didn't see the assault rifle during the transcript. I wonder when you look at all of that, how there was any effect of an error on the jury in this case, no matter what test we look at.
I don't read the transcript the same way. I don't think it's clear that they didn't see the assault rifle. I'm guessing that, I believe the record reflects that it went back into evidence and they had the ability to view it. So I don't think we can.
I'll leave you with one more thought, because I didn't catch it until literally yesterday, when I was just finished my secondary review of this transcript another time. At the very end, go back and check. Looks to me like trial counsel didn't object when the trial court said, look over all of the evidence after the trial and decide what you're going to go back to and what's not going to go back. My experience in criminal felony judging is that you always have the lawyers get together afterwards and decide what they agreed or didn't agree to go back. Obviously, we don't send guns and bullets back together for a safety reason. We don't send fentanyl back.
Right, but they're sending a video back.
But if somebody says, who had objections to the entire video being shown, then says, I don't object, and the video is going back, I wonder if that is an invited error at that point. I'm sorry to spring that on you, because I just caught it yesterday.
I think certainly not. I think at that time it's objection for the trial, and this lawyer's making an objection, the judge is leaving the bench and not addressing his redaction objections.
I'm not sure that's the case though, because 3400 is a discretionary rule. So 3400 basically says that the trial court may send back exhibits. It doesn't require the trial court to send back exhibits. So there's nothing that suggests to me that the trial court at that moment couldn't exercise its discretion to say, for example.
We're suggesting that the judge is going to, at that point, not let the video go back after they were arguing back and forth.
Sure.
Repeatedly, and she's going to change her.
No, I don't think so. I think it's more along the lines of she would do what she did. And this is only if you buy into my reading of the transcript, which.
It's 11:07 if you want to address it on rebuttal counsel. So 11:07 is the, when the video is shown, and there's a colloquy with the court afterwards that it does seem like it appears they pressed stop before the rifle was shown.
And there's just the rest of the video has his audio over the top of it, and not when he says, and this is the other, which is when the 2 seconds of the rifle is on there. I realize I'm eating up your rebuttal.
No, I understand. I feel like,
but I would say also that,
I feel like we're guessing now that they didn't see the assault rifle, and when the judge permitted the entire video to be played, and now we're guessing that it wasn't shown.
I think it's pretty clear.
Counsel, I would think it would be most useful to maybe glance at that page of the transcript so you can address it specifically with us, because the judge just called them up and there's a colloquy where they appear to be talking about the fact that the video was stopped before the rifle came. The portion of the discussion of what evidence was going to go back, that's on 1281 and 1282. So maybe having looked at those pages in the transcript,
Thank you.
have to
I'll say that
open
for
up the
rebuttal.
conversation.
Thank you.
May it please the court. My name is Richard Palace. I represent the state of Florida. To get right into issue 3 here, it is our position that this is harmless error. And I think opposing counsel mentioned earlier about the hearsay cases being possible examples. And when I evaluate that kind of case law when it comes to these types of evidentiary rulings, I realize, Your Honors, that 403 and 402, the case laws, we almost have a dearth of it when we're bringing in whether it's harmless in a lot of these, except for some of these firearm cases that were, of course, quoted in both the initial brief and reply brief. But I recall reading on the hearsay cases, when we're talking about the reasonable possibility that it affected the verdict, there's case law that speaks on whether the error is unimportant in relation to everything else the jury considered on the issue in question as revealed in the record. And that's how I sort of look at this, is whether this evidence comes out to being unimportant in regards to everything else we have.
Does that essentially come down to overwhelming evidence?
I believe overwhelming evidence is part of this analysis, Your Honor. The state acknowledges that, of course, under DiGuilio, all of our harmless error case law, overwhelming evidence alone is rejected. But I believe overwhelming evidence plays a part in whether this evidence is unimportant. If where we have here, almost so much of the case that the state focused on was about actually hyper technical details as to how defendant's phone started in the South Florida area, traveled up, laid in wait at the victim's apartment complex for 30 minutes, then was at the murder scene, in all of the camera footage that we have showing someone in this tracksuit, this distinctive tracksuit that multiple law enforcement officers all testified to noticing.
Does that essentially come down to overwhelming evidence and the improper evidence wasn't a major feature of the trial? Is that kind of a two-parter?
Yes, Your Honor, that is part of it, because at least when I looked into all of the case law cited regarding, at least we were looking at 402 and 403 objections, whether we were looking at cases like, I think, Green, Matayer, Jean Bart, and Downs. In some of those, we had issues where, I think it was in Downs, there we had the firearm was irrelevant because the murder weapon, I believe, was not automatic. It was an automatic weapon found. I believe this evidence was actually argued in the state's argument as indicative of guilt in the particular Downs case. And the jury wanted depositions from witnesses of which, as acknowledged by the court, had holes in what they looked at. Further, the victim did not identify the defendant at first in that case. I move into the Jean Bart case.
We're just looking at the rifle at the end of that video. Do you concede we're on 401 as opposed to 402 or 403? I mean, I just don't see the relevance of a gun that wasn't involved in the shooting.
I believe we are looking at relevance, and that's what most of the case law stops on, whether or not
Right, so
another
we're not
firearm
really
was
looking at prejudice in the context of anything other than harmless error, or whatever that test might be.
Yes,
Is that
Your
fair?
Honor.
Okay, so if we're looking at just it being a mistake, an error, then I think we're right into the harmless error analysis. Do you agree?
Yes, Your Honor. If we agree the gun is, of course, not relevant to this case, that doesn't make any fact more probative or not, at least regarding material fact, we go straight to harmless error. Because if we prove relevancy, of course, we have to prove that was not substantially outweighed by the prejudice here.
I know you didn't write this brief, but what's the state's burden as it relates to telling us what the harmless error is?
I mean, our burden is, of course, showing beyond a reasonable doubt that this error did not affect the verdict, and us then meeting the reasonable possibility that it did not affect the verdict test. Our burden only starts there. Burden is otherwise on the appellant to show the error. And while we did not touch as much on the relevancy, touch as much on the prejudice of that particular firearm. I mean, goodness knows the state wanted this to get in just to talk about the multiple guns here and the fact that we have two different Glocks that appear in some of our footage. I think that they ended up not, if that comes out that they stopped playing this video, then it does not matter. But of course, they say, here's one, here's another one. The jury might wonder, what other guns are we talking about? But
Counsel, can I ask you that? I take your point about kind of the overwhelming evidence, plus this particular evidence wasn't a feature. I can see why that would make some sense. I want to talk about whether you made that argument in your brief and whether you had to. And so I just relooked at the brief to refresh my memory,
yes, Your Honor.
and you really don't make that argument at all. You definitely make the overwhelming evidence part. There's several paragraphs where you say, and it seems to be a pretty straightforward overwhelming evidence argument. I mean, the first line of your harmless error analysis is the evidence of appellant's guilt was overwhelming. And then you've got several paragraphs of all the evidence that you view as overwhelming, which I get. There's really nothing in your explaining. I'm not saying this means you're wrong, but there's nothing, at least in the brief, explaining why the video wasn't a feature, why you would meet that second prong of the test you just articulated. So it's the precedent of this court in Smith v. State and Middlebrooks v. State that we do not make harmless error arguments for the state. And that was based on the harmless error case law from the Florida Supreme Court saying it's the state's burden. And the state's burden means they've got to make the arguments, us making the arguments, and the court making the arguments for you, and it being the state's burden are irreconcilable. If it's the state burden, the state has to point it out to us and establish that it is harmless error. So if we were to accept your framing of kind of an overwhelming evidence, plus the improper evidence wasn't a feature, I get that. You didn't make that argument in the brief.
Yes, Your Honor.
Our case law says to you, you have to articulate it to us. Where does that leave us?
Well, Your Honor, acknowledging that case law, I'm familiar with those opinions on this. I would first, to get into that, while of course we were not as artful saying anything other than overwhelming evidence, I think it's the second to last sentence of either the second to last paragraph or the one after it. We make a mention of other evidence of Glocks coming in through either, I think, the text messages showing the phone, or I believe there were the phone calls, of course, discussing Glocks in that. And while, of course, that can play a part in this being unimportant because in all the case law discussing those cases, if we have other evidence of the inadmissible evidence, then that plays into the harmless error analysis.
Forgive me, I'm talking about the rifle.
Oh,
right?
yes, Your Honor.
The rifle. There's nothing in here that I see. I'm looking at your answer brief. There's nothing explaining how or why the rifle wasn't made a feature or couldn't have been expected to influence the jury, other than to say the evidence was otherwise overwhelming, which you lay out your argument on that fully. But there's nothing you articulated a two-step test. Overwhelming
Yes.
evidence and plus the improper evidence wasn't a feature. And that test kind of, I can understand, that makes logical sense. That actually does kind of square some of the, assuming it was correct. It
Yes,
does
sure.
square the workability at least. It's not in your brief.
If I remember correctly, Your Honor, I believe we still cited to the Duilio case in discussing the harmless error analysis in this. And some of our harmless error analysis or analyses, I believe, bleed together when we're discussing some of the other evidence in here from issues 3 through 7, mostly 6. I don't recall us discussing it with cumulative because obviously we're arguing here that we have no multiple errors. But in getting into that, Your Honor, I believe at least citing to the Duilio case, of course, puts the court on notice of what the full correct test is. That, of course, we're not just.
That's just the bare assertion we meet the test. That's not an explanation of why the rifle wasn't a feature. I mean, if just saying you meet the test is enough, then all the state's got to do is cite Duilio, and it's always meets the burden without actually articulating why the test of Duilio was met.
Yes, Your Honor, understandable. Of course, because that certainly just citing to a case and saying there was error, the defendant doesn't meet their burden at all when appealing their judgment and sentence. So I understand that, Your Honor.
Do you accept that Middlebrooks and Smith are right in the context that it's exclusively and always the state's burden to show harmless error?
Your Honor, I think before this burden should shift respectfully to those cases, I know, I think we're normally playing into, if I remember the statute correctly, it's 951.051, but I might be off on my
There's like
numbers.
3 harmless error statutes.
They play into here. I know with my assessment of at least a decent amount of case law, including getting sidetracked here with what's been getting discussed with all the Erling or Fallout litigation, is that the defendant has to show prejudicial error. And, not just showing something was irrelevant, something was harmless, or I'm sorry, showing something was irrelevant, showing it was prejudicial. They also need to show how that actually prejudiced their case.
Wouldn't that be the opposite of it being the state's burden to show harmless error?
I believe it's almost like a volley, Your Honor. It is, they need to show that prejudice in order for us to then have our burden triggered.
So they have to show it's harmful. Then that shifts the burden to you to show it's harmless.
Yes, Your Honor. At least that's how I read I think the 501 statute I'm referring to.
Okay, how do you square that with, all the Supreme Court's case law saying that once an error is shown, it is the state's burden to show that it's harmless?
Your Honor, I believe at least squaring up with all the Supreme Court cases, I'm not sure if they looked at that, if that case law specifies it being a sole briefing requirement of us, delineating this particular argument that I'm making here now, specifically within.
Well, what they say is once an error is shown, it's the state's burden to show it's harmful. Okay?
Yes, Your Honor.
And so I won't be offended if you think Smith and Millbrook's are wrong. I won't be offended. But
Appreciated, Your Honor.
But to me, if it's the state's burden saying the court put it for you, those two things cannot both be true. Right? It cannot be true that it's the state's burden. And also, if the state doesn't do it, the court will do it anyways. So if it's not in the brief, like where's the, hey, if you I guess you flushed it out as much as you can. I'm still having trouble wrapping my head around it.
Me too. It's a
Yeah.
little confusing from the standpoint that you've got DiGiulio talks about it being the state's burden, which to me suggests where you went, either notice or ultimate pleading facts.
Yes, sir.
It seems a little bit odd, and I appreciate you saying it because it seems a little bit odd to me that we would hold the defendant to all those waiver cases that basically say just a bare assertion isn't enough and not hold the state to it. I'm, I guess, a little bit confused by a variety of Florida Supreme Court cases, including Goodwin, Jackson, Hughes, that basically talk about us having an independent obligation to review it on our own. I don't know how to square that with it being a state's burden.
Well,
Yes, Your Honor.
no, I'm sorry. Go ahead. I didn't know.
I mean, obviously, I know we're getting into kind of territory of, courts taking on Anders on their own volition and the like. Obviously here, the Supreme Court doesn't overrule itself, sub silencio in these cases, but if they are mentioning courts also undertaking their own harmless error, I believe it still gives the state the opportunity to possibly flesh out its analysis more, at least in this case. I know I'm almost shotgunning these arguments.
Are you basically saying you're entitled to meet your burden at oral argument?
Your Honor,
I'm
at
not
least
saying you're wrong.
I think if we try to square DiGiulio with the Jackson and Hughes cases and the like, talking about the courts having their own, I believe that still gives the state its other shot here. And again, I would like to think that while we do not mention a few specific words in our brief here, still discussing DiGiulio, knowing its reasonable possibility, and focusing on overwhelming evidence. Here, we're mostly just keeping our focus on the fact that because this evidence was so overwhelming, there's no reasonable possibility that it affected the verdict.
Did you come across in your preparation for this or otherwise, there's a case that Judge B.L. Thomas wrote on the first called Thornby State. It's a 2019 case, and he basically said that, Ventura, the last time I think the Florida Supreme Court said unequivocally, we explicitly reject overwhelming evidence. That was 2010. 2019, Judge Thomas writes an opinion saying courts are pretty much using an overwhelming evidence test. He said they're using the overwhelming evidence test. And he said there's another test we see them using, which is basically a kind of a less rigorous test than the one you articulated, but two-part, which is that whether the defendant's guilt was established by other evidence unrelated, not the improper evidence, but a bit farther unrelated to the improper evidence, which almost to me is kind of a sufficiency of the evidence test, aside from any evidence that was related to the improper evidence. That kind of speaks to me the way courts have struggled with this, because 9 years after Ventura, courts are still saying, yeah, look at all these cases using overwhelming evidence. Did you have any thoughts on his analysis of those two tests, or?
Your Honor, his analysis in Thorne, while I am not familiar with that opinion, I know at least as recently as 2021, the first DCA had harmless error analysis from Judge Winokur. And I think it was the Schluck case that came out from there that was regarding hearsay. And that one regarding whether that evidence was unimportant with the verdict. So I think that plays into what Judge B.L. Thomas on that court was discussing. And goodness knows if that is a type of analysis that I would agree we would definitely meet here under Judge Thomas. But of course, if this court requires additional briefing on, of course, any of these matters, the state would certainly be willing to get into that, just because I know this court has its decisions in Middlebrooks and the like regarding our burdens. But I think here the court's struggling with all of this. I think as we build from DeGuilio, getting into Ventura and the like, and saying we're not solely overwhelming evidence, while that is true, it's not solely overwhelming evidence. I think in certain cases, if we can get into saying this is overwhelming evidence, we thus meet the reasonable possibility that the error did not affect the verdict.
Do you agree with reading the transcript that the video, the portion of the video showing the rifle was not shown in trial, and then counsel consented to the video going back? Is there any reason, I mean, in your view, does that move the issue? But it's because it wasn't shown to the jury during trial, so it's not error. And then when it goes back to the jury, there was consent, it was invited error.
Yes, Your Honor, if that is what the viewing of the transcript says here, then certainly it's waived error and there was nothing for the jury to view. I think it's important. The jury's question had nothing to do with that. The jury just wanted to review the medical examiner's testimony, and then it had some questions about the knowledge of whether the victim was pregnant, if I remember correctly. In this case, there was nothing questioned about this particular video. Of course, I can't get into what the jury necessarily reviewed, but there were no objections made at the time that evidence was sent back, from what I could tell. I know that, of course, this video was heavily objected to. I will note, for one, assuming preservation, the discussions of redactions were not done in front of the judge. And when this evidence was then played, we didn't even have, while there was then another subject to prior objections and talking about how this evidence was damaging, there was still no additional, can we redact this? And if the state did stop it, then in theory, that portion regarding the rifle, whether an assault rifle or shotgun standard rifle, that's just not reviewed by the jury in this case, and there's no error to be corrected.
I guess we've gotten to this point in criminal felony courts in the district where we're sending back non-connected laptops to view video evidence, and that's become pretty common.
Yes, sure.
But I just wonder if you're in a situation where that wasn't available, you of course wouldn't send back a laptop that was connected to the internet to allow the jury to do its own independent research. You would just basically, anytime that the jury wanted to see something, just like when they wanted to see the gun or hold the bullets or look at the cocaine again, we'd call them back into the courtroom.
Yes, Your Honor. Typically, at least with readbacks and everything, we don't send the court reporter back there with them. We bring them in here, and the court reporter will then do the readback for them there. So I believe that if they wanted to view this video again, we would probably have had it happen here.
Well, no, I mean, it went back with them, so they could have looked at it and we wouldn't know about it.
Yes,
And
sir.
that wouldn't have come back out to the court. But the issue is whether so if it went back to them, you could see why that might be error, right? But if there was no objection to it going back, and there was in fact, from looking up the transcript, agreement for it to go back,
Yeah.
that would make the error, not error, but invited error.
And I know this court has a prior opinion, I want to say either a year or 2 years ago, discussing whether subject to prior objection is sufficient for.
Zolo.
Yes, that case, discussing whether or not the statutory requirement of preservation and our common law preservations can, be reconciled in that case. And arguably under that, you would say that this is not preserved under that type of principle, I think, Your Honor.
Well, also, I don't think that would be, I mean, there, you have to, the issue is whether you have to renew your objection. Statute says you don't, Supreme Court says you did, but that presumes it's the same objection.
Yes.
Here, it's two different issues. One is the video being shown to the jury. And, you know, that's one decision to which the trial counsel did object. The second is the discretionary decision of what evidence goes back with the jury.
Yes,
So
sure.
to me, it wouldn't be a renewal of the objection because that's not the same issue. That's a new issue.
I
And there
understand.
wasn't just a lack, it seems reading the transcript, there wasn't just a lack of objection, there was agreement. There was, we agree this can go back.
Yes, sure.
That would, anyways.
Which I guess would play possibly more into waiver or inviting error at this point than be an actual preservation issue.
Just to confirm, the state's position reading this transcript is that the video stopped before the assault rifle was shown in the video.
That, Your Honor, that was not something that came to mind when I first went through this transcript, but when that question was posed during the topside argument, I went to go back in there and I see you read my mind. Yes, I stopped it before. That I know this video is only 27 seconds and the firearm is only, or the second firearm is only about 3 seconds of that before it goes back to his face, if I remember correctly. So it would seem, I don't see why they would stop it short to him returning the phone to his face, because that was what the state wanted to have in. So I would agree, Your Honor, that if they were to stop it somewhere, they would stop it at the assault rifle.
Thank you.
No, thank you, Your Honor. I see that I've gone into my time. So if there are no other questions, I will rely on the state's brief and I ask that you affirm.
Thank you. I give you an opportunity just to address those transcript pages that we sprung on you at the.
So I agree, the transcript on 11/7 suggests that the assault rifle was not shown to the jury. As the state indicated, this is a very short video. Generally in these transcripts, when the transcriptionist says you can't rely on this as an accurate depiction of what the audio and video is. So I still think we're speculating. Say that there should have been a separate objection. I think it's a futile objection when the trial court said as a whole, the video was admissible and walked off the bench when the lawyer wanted to make an argument about redaction. To say that another objection would result in a different outcome is, I think, not reasonable.
What if the objection was, hey, I object to that video going back. I would like that to be played in open court and I would like the state attorney to stop it before the
He made that objection and she left the room. He said, I want to redact, and she says, no, I've heard it all.
That was when they were talking about what evidence is going to be presented to the jury, not what evidence is going to go
No, I
back.
understand, but I mean, as a lawyer, are you actually expecting a different, I mean, she didn't just say overruled or let me, or listen to his argument. She said, I heard it all, we're not redacting, and ran out of the room. I mean, this is an extreme example of a judge saying, I've heard enough, I'm not addressing this. So to me, it's a futile objection. I don't see any other way to read it. You know, he's just agreeing that he's not agreeing that he thinks it should go back. He's already made it clear he doesn't think the jury should see it. The judge has said the jury can see the whole video. He's just saying, yeah, nothing's been slipped into this that wasn't admitted. He's not saying explicitly, oh yeah, I agree that they should see this. He's saying, yeah, those were the 4 exhibits that were introduced, so it's okay. Yeah.
Do you want to finish up with any, we've asked a lot of questions into your time. Do you want to?
Well, I think
finish up
Judge
with
Mize is in, you know, I think the reading of the cases where it says the burden's on the state, I don't think there's any other way to read it. If they have a burden, they have a burden. And neither in their initial brief, in their answer brief or today oral argument, have they explained why the firearm distribution, text messages and audio, why the assault rifle, and why the video of Mr. Pierre bragging about his genitals is not prejudicial. They haven't said it today and they haven't said it in their brief. I mean, of the things that a juror expects to see at a trial, I think a video of a man bragging about his penis being the equivalent of a gun is probably high on the list of things they don't expect to see. And the lawyer makes a
Was that
record.
chased out at all, though, by trial counsel's appropriate and good objections to the notion, and it goes to weight as opposed to admissibility? You can't tell that that's his hand on the gun in the other picture. You can't tell that that's his living room when it shows the Glock
I
on
don't
the
know.
ottoman.
They repeated?
Yeah, so the response to I need to show his face in this particular video, face, genitals, gun, is the idea that the other block pictures don't have Mr. Pierre's face or any other identifying feature in them. You could say that one of the pictures wasn't a picture of Mr. Pierre's living room. The other one is a hand holding a gun. And the argument is, well, that's not his hand. How do we know that it's his hand?
Well, I agree completely with the court that the jury gets to see his face. We, apparently the state wasn't able to do this, but we were able to redact the video in about 5 minutes yesterday. And we redacted the video where you see his face. This is after he displays his penis. You see his face, you see him walking over to the Glock and pointing to the Glock. So you see his hand, you see his face, you see the Glock. That satisfies the court's concern.
I have two more questions for you, and I know we're over into time. But number one, do you agree with or I guess, what are your thoughts on the test articulated by the state's counsel that it's not overwhelming evidence, but it's overwhelming evidence, plus it wasn't a feature? I'm not saying that was met in this case when they argued it.
Sure.
Just whether or not that's a decent way to look at it. And go ahead.
A feature. So, it's so hard to say what a feature is, I'm guessing that one of the, even if that's, I don't know if that's the appropriate test or not, but if it is, I'm guessing one of the things that each juror mentioned to their significant other when they got home is, I saw the defendant bragging about his penis on a video. So to say that's not a feature because it was a short period of time, I think is different than if it was like a hearsay objection. I mean, that's a pretty blatant thing. It's a pretty, so even if feature is the standard, then we have a long, multiple paragraphs of discussions about him dealing in firearms. It has no relevance. And the state hasn't explained today why it's not prejudicial or why that wasn't a feature. And all this stuff went back to the jury room. So now we're speculating that they didn't look at it.
So that kind of goes to your prior argument that maybe another component is how inflammatory was the error.
Yes, and Ventura, as the court said, is the last time the Florida Supreme Court addressed this, and they said you have to look. It says application of the test requires not only a close examination of the permissible evidence, but an even closer examination of the impermissible evidence, which might have possibly influenced the jury. And I think that's where the states failed to meet their burden. They haven't told the court in any shape or form why this wasn't prejudicial.
But the last question I have here, I know we're over time, your comment about the iPhone video, and this goes to a question I've been thinking about, which is when you say an iPhone video can't be edited, that's obviously wrong. You can edit an iPhone video on your iPhone. There's numerous software programs to do that. Entire movies have been shot on iPhone. So the idea that this video just couldn't be redacted seems to not pass the common knowledge test. So the idea that it's a factual assertion though, right? So the idea, I know in this case that your client's trial counsel didn't get the chance to view it or, to ask further questions about the ability to redact and run that to the ground. I get that. But aside from that, just this idea, even if it had been run to the ground, that wasn't an issue here. If there's some factual assertion that is just obviously wrong, like say the argument had been iPhones don't make phone calls, right? We would not on appeal say, well, that's a factual assertion and there's nothing in the record to dispute it. We would say, that's obviously nonsense. It's contrary to common knowledge that every cognizant adult has. iPhones can make phone calls, right? So this idea that like the video couldn't be redacted, I'm not saying it's on the same level as iPhones can't make phone calls. But I guess my question is, how obviously wrong does some factual assertion need to be before you would say, or we would say, this isn't the type of thing where we're going to say, oh, this is a technical issue or we can't go outside the record. The sky is not green, grass is not blue. Some things, it doesn't matter how confined in the record they are. We just know they're wrong because it's common knowledge. But when you say an iPhone video can't be redacted, where on the spectrum is that? And how far along that spectrum of, a highly technical factual assertion to which we would obviously, obey the normal, idea that we can't think of things outside the record, and just obviously false things that every cognizant person would know are false, that we would say if that's in the record, it's obviously wrong. how far on that spectrum between those two things before we can treat it like the sky is green? And where does the iPhone redaction fall in that?
Well, if ten is being the most absurd, then we're at ten. I think if the court's at an eight, we're good. But I think the record even supports the idea that there was measures that could have been used to preclude the jury from seeing the assault rifle. Because now we're disputing, because apparently, even though the defense lawyer is arguing for redaction, the state continues to argue for the whole video to be admitted, doesn't offer at the time of the argument to pause it, but then later finds a pause button. So even if you don't have to redact it, you could pause the video at different parts to make sure they didn't see either the penis bragging or the assault rifle. So even if redaction, which, you know, actually cutting it up wasn't permissible, you do it all the time in court. You fast forward to 4 minutes of the video because the first 4 minutes aren't admissible. Or you don't show the last 10 minutes of a defendant's statement because he invoked Miranda. You hit pause. So it's absurd. It's a 10 out of 10 that it's absurd that there was no way to address the objection and show irrelevant evidence and prejudicial evidence to the jury. So for those reasons, we'd ask the court to reverse Mr. Pierre's conviction. It's not an overwhelming evidence test. And the prejudice from the evidence in this case is just too high, given the serious nature of the case. This is a shooting of a young woman with an unborn baby. And then you have a defendant mockingly calling his genitals a gun and displaying assault rifles.
I'm gonna ask you to wrap it up at this point, Mr. Pennell.
Thank you.
Thank you. Appreciate the time that everybody spent on this. You know, you never know what's going to be interesting to a court as it relates to a long and well-briefed appeal on each side. Thanks for indulging those questions. We'll be in recess.
I want to thank the court for sending the order telling us what to address. That's super helpful.
Thanks. We'll be in recess until 10:30.